Hey out there, legal warriors. In this video, I'm going to cover something that most people would think is counterintuitive. I'm going to cover the situation where if you've got a criminal matter and you have a civil protection order against you out of the same matter, why it might be a really good idea to agree to that civil protection order against you to help you in your criminal case. Lance, that doesn't make sense. Yes, it does. Stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now, as always, I'm just going to jump right into it. I'm talking about a unique but yet common situation. It's both unique and common. If you got a domestic violence charge mainly, and you've been arrested for domestic violence, what often happens is that the alleged victim, they go out and they file their own civil protection order, separate and apart from whatever criminal charge is going on. And if you've watched this station for a while, you probably realize that there's many instances where someone gets arrested for a crime, but they are not immediately charged with a crime. And those examples would be any type of felony charge, where an officer only has the power to arrest but not charge, or any type of case that involves a geographic area where the sheriff is involved or the state patrol is involved, because those people, for the most part, they can arrest, but they cannot charge. And what does that mean? Usually then there's a period of time, weeks or months, between the arrest and the charge. And what often happens is that victim's advocate or someone in a domestic violence case or in an SA type case also, in those type of cases, they'll actually tell the alleged victim, hey, they're not going to file this case really quickly. It takes us a long time to file, so you're not going to have any protection. So dear alleged victim, why don't you go out and get a civil domestic violence protection order, civil anti-harassment order, civil order of some type against the suspect. And so the suspect gets arrested, they don't get immediately charged, they're out of jail, and they think, great, I don't have to worry about anything, and then knock. On the door comes the police and go, hey, here's a civil protection order. You can't have any contact with this alleged victim. Now, when you get that civil protection order, there's a petition with it, and the petition is going to be very useful for yourself and for your criminal attorney if you have one, because that petition is usually going to write out some details of whatever got you arrested, their version of whatever got the suspect arrested. And sometimes those details are going to be very helpful for us to understand pretty quickly what the alleged victim told the police. There might even be a police report number, and if you're really lucky, they might attach a police report that they got a hold of sometimes quickly. And what do you mean lucky, Lance? This sounds terrible. Sounds terrible. Why is it good? Well, I'm not saying it's good that they served you with an order, but what we have to think about is what happens when we are being investigated for a crime versus defending a civil order. What is the civil protection order? That is not the government versus you. That's the alleged victim, who's listed as petitioner, versus you, who's listed as respondent, not defendant, respondent. The civil order doesn't put you in jail unless you violate it. It's not a criminal matter, right? And how you typically respond to a restraining order, a protection order, is you're expected to go to court and write out your response to it and file it with the court, and you can testify about what happened. But if you talk to an attorney and you've been arrested for a crime and the order is about the same subject, you probably don't want to do that, because anything you say in that civil court can be picked up by the prosecutor and used against you in the criminal case, right? I've talked about this a couple times on the station and some video out there where it's like, a hypothetical would be, well, the alleged victim says, he punched me in the face, and you get in court and say, I didn't punch her, I only kicked her, right? Well, you just admitted to a crime with the kicking, but, you're right, you didn't punch. And so you want to be really careful, and therefore you might be in a position where it doesn't make any sense to defend it all anyway. You maybe can't even defend it rationally because you're exposing yourself to criminal liability. Now, there's lots of exceptions to this, but here's what we often say. We think about the psychological situation going on. Let's say that you got arrested. There is no criminal charge yet. The victim goes and gets a civil order, and you're deciding what to do. Well, sometimes it's best that the person who's the respondent, the suspect, goes to that civil order court and says, hey, I can't respond because I've been accused of a crime. And while I'm not guilty of anything, I don't object to the issuance of a 1-year order. You say I don't object to the issuance of a 1-year order because they can issue a lot longer order. And if the alleged victim gets their protection for 1 year, it sort of changes the game psychologically. Let's say they get their protection order for 1 year, you agree. Let's say, for sake of argument, that happened on June 1st of a particular year. Let's say it's December 1st now, and the prosecutor now is getting around to looking at the case. And let's say it's a so-so case. It's not a slam dunk case. Well, they might get a hold of the alleged victim who already has their protection order. They feel protected and say, hey, are you still disinterested in the case? Well, they may be less interested. More time has passed and they already have their protection order. Also, as a prosecutor, you feel less pressure to file a case just to get that protection for the victim in the report. I was a prosecutor for 7 years, so I have some idea how prosecutors think. Everyone's different. But if there is no order in place, let's say somehow you go to that civil order and you win the order. The judge doesn't believe the other side. That can be helpful, but the prosecutor doesn't really care that much. They care what's in the report. Now that victim has no protection. They're more excited to get you prosecuted now and get that protection from court. And now the prosecutor feels more obligated to file that case. And so there can be an advantage to sort of tamp down the motivations and the willingness of alleged victim to participate in a prosecution, especially from your point of view, if they're sort of making it up or exaggerating it, right? When people put a lie out there, if they get something they're looking for out of the lie, they're less likely to go through the mental energy necessary to maintain the lie later. It's tough to maintain a lie, right? It takes effort to continue to maintain a lie unless you're a pathological liar, right? You know, and we won't talk about politics nowadays. But as far as that goes, that's why oftentimes we will advise our clients, hey, it might be a good idea we go to court and agree to a 1 year order, because it doesn't even make sense to fight it if we are exposing you to stuff the prosecutor might use, and they're probably going to win it anyway because you got arrested and the standards are so easy to get orders, so they're going to win it anyway. Why don't we go and tamp down on the conflict and make everyone feel a little better, so 6 months from now or a year from now, there's less of a reason for people to want to follow up and have you prosecuted for the charge. So there's defensive reasons, offensive reasons, and psychological reasons why sometimes that can be the right decision. Quickly, when isn't the right decision? Well, let's say we've got really great evidence that you're totally innocent and we had all these lies on the other side. Sometimes we will aggressively fight an order because we think we could win, and the theory is if we win that order and we put your stuff down beautifully, taking into account the criminal issues, sometimes we could use what we wrote to get that to the prosecutor to say, look, your case sucks, right? But that's case by case. It wouldn't be something anyone would want to try to do on their own. And, at least 8 times out of 10, that's probably something we wouldn't even consider. So I've explained quite a bit here, so I hope you found it useful. If so, please like and please subscribe. More people get to see it. More people get this type of help that they really need. And finally, if you've got a criminal matter or protection order in Washington State, feel free to reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.